Hello and welcome to Legally Speaking. This show is being brought to you by the Georgia Association of Black Women Attorneys, also known as GABWA. My name is Jacqueline Bunn and I serve as your host. Today we'll be talking about employment issues. This show is not meant to provide legal advice. If you have a legal concern, it's important that you contact an attorney. I have two outstanding attorneys here today to talk to us about some employment issues. Their names are Ruth Woodling and Tamara Woodard. Welcome, ladies.
Thank you.
How did each of you get involved in the practice of employment law? Ruth?
I had a female law professor who took on a case without charge. It was a high-profile pregnancy discrimination case, and she asked if there were any of her students who wanted to get involved with her in handling the case, and I was one of those students. The case eventually went to the United States Supreme Court.
Wow.
And we won. And that case established the right of women to work past their 4th month of pregnancy. And those of you who are under 40 don't understand that prior to that time, almost every employer in the United States made women leave their jobs when they got to be 4 months pregnant. So that case changed all that. And at that point, I was just hooked. You know, I was very interested, and I had some expertise, and I stayed in the area.
Okay. Tamara?
Well, my entry into the profession was not nearly as exciting. But after undergraduate school, I started work at Chrysler Corporation as a labor relations person, and I did a lot of work with the union advising employees of their rights. So it seemed a natural progression for me to go into employment law once I finished law school.
Okay. What kind of disputes do you see in the workplace?
Well, all kinds of disputes relating to employment. Of course, employment discrimination covers race, religion, age, sex, national origin, disability, veterans status, and even some more. I don't know whether you can think of any others, but it's very broad, and we see all of those. I'm sure that you do in your practice.
See all of those. We also see disputes between employees, disputes with, I work for a telecommunications company. We see disputes with vendors and suppliers that we have to deal with. So it's not limited to disputes between the employer and the employee, but also employees and who we do business with. We see a lot of those disputes as well.
You're talking mostly about sex harassment situations?
A lot of different type of situations. Sex harassment is one that definitely comes to mind, but also, you know, sometimes improper dealings that might affect the employment relationship, conflicts of interest and things like that.
All right, well, let's take a step back and just talk about what is discrimination.
Discrimination is basically treating one person differently from another person. And not all discrimination is illegal, and not all discrimination that employers engage in is illegal. For example, an employer can discriminate against someone who doesn't show up on time and in favor of someone who does. They can discriminate against someone who violates the safety rules and in favor of someone who does. But the discrimination that we're talking about is illegal discrimination, and there are state and federal and local laws that protect certain groups. And those groups are related to, you know, sex, age, as I said before, national origin, religion, veteran status, and a myriad of categories. Now, if you treat somebody differently, if you're an employer and you treat somebody differently because of one of those, they belong in one of those groups, then that can be a violation of the law.
Has the law kind of evolved since that case you worked on?
Yes, it has evolved, but the categories have pretty much stayed the same. I can't think of anything that's been added in the last couple decades, can you?
Well, I think we're starting to see, not federally, I think you were talking about particularly in a state like Georgia, which doesn't have any state laws protecting a lot of the protected characteristics. But in some states, we are starting to see some sexual orientation discrimination added to the list of protected categories. But that hasn't made its way to Georgia yet.
That's a good point. Actually, the city of Atlanta has a non-discrimination ordinance that protects sexual orientation and gender identity. I guess I can call it a problem with the ordinance. It's cumbersome, it's difficult to work with, and you really have to continue to pursue things. There are two routes, one through the city council, one through the municipal court. And the procedures aren't well established, so it's difficult. But if you want to bring an action based on your sexual orientation in Atlanta, that's where you have to go.
Okay. What should an employee do if they feel like, discrimination has occurred?
Well, the first stop, and I'm an employer and lawyer for management, as we say. So your first stop should always be your human resources department, I think, or whatever type of internal complaint procedures your company has. Most companies have them. If they're a responsible company, they have them. But you also have other remedies. It depends on what state you're in or what locality you're in, because there may be some local ordinances, as Ruth was just talking about, that might protect you. There may be some state laws that might protect you. But if you have a federal claim in Georgia, you would go to the EEOC and file what's known as a charge of discrimination. And that is required, a prerequisite, to a lot of the forms of discrimination that people face within the workplace. If you don't file that charge of discrimination within 180 days, generally, it depends on the facts of the case. Sometimes it can take longer if it's a pattern of discrimination or harassment. But generally speaking, if you don't file that within 180 days of whenever the incident occurred, your claim is barred, which means you won't have a right to file a lawsuit over it anymore.
So should you, is it a federal EEOC or a state EEOC?
In Georgia, it is federal.
Yes, Georgia really doesn't have any state laws applying to private employers that deal with these areas, so you have to go through either the federal law, or you can, as we mentioned, there's an Atlanta city ordinance.
Okay.
And some cities outside of Atlanta probably have some local ordinances.
Yes, they do. I actually went and checked on municipalities that had sexual orientation ordinances, and there aren't many. Mm. And no other big cities. DeKalb County has one. Mm. Tybee has one down near Savannah. Doraville has one. East Point has one. And Athens-Clarke County. And those were the only ones that I could find. But other than those, you'd have to go through the federal procedures.
Okay. Let's talk specifically about some of the different types of discrimination and what kinds of cases actually arise to the level of something that someone could pursue. Mm-hmm.
Well, you can pursue anything, right?
And we will take a charge from a rock.
That's right. We see that all the time. You can pursue anything, and I mean, if you think you have a claim and you don't know, you should pursue it, because otherwise, as I said, if 180 days passes, then you waive your right to. Yeah. So if you think you have a claim, you probably should at least go to the EEOC just to protect your right. If it turns out that, once you go to the EEOC and you talk to a lawyer and a lawyer says, probably not a good case, you've at least protected yourself.
There are a couple laws that don't have that 180-day requirement. One is the Equal Pay Act. They're almost all related to the Fair Labor Standards Act, which relates to how you're compensated. One is the Equal Pay Act. The Equal Pay Act relates only to discrimination between men and women with regard to their pay.
Okay.
Okay. The other that has a longer, and that's 2 years, and if it's willful, 3 years. The Age Discrimination and Employment Act has a 3-year statute of limitations as well. And so the Family Medical Leave Act also.
So those don't have an EEOC requirement, but they do have a time requirement. I mean, most laws have a statute of limitations, is what we would call it, but most laws have a statute of limitation, and yes, the FMLA is Family Medical Leave Act, or as we jokingly call it, Friday, Monday Leave Act, has a 2-year
spoken as an employer.
has a 2 and 3 year statute.
There's one other statute that is interesting that has a longer statute of limitations, and that comes from the 1866 Civil Rights Act. And we know it as 42 U.S.C. 1981. And that protects only race and national origin or ethnic origin. And it comes from the 1866 Act, which says that all people within the jurisdiction of the United States shall have the same right to make and enforce contracts as white citizens. And employment is a contract. So that law has been used, and the statute of limitations is 4 years. There's no limit on the damages.
That's right.
And so there are some advantages to that particular statute if you have a claim that is based on race or national origin.
Okay. What about age discrimination? When we talk about age, what's the age range where you can even assert something like that?
Anything over 40.
And by the way, since the law was passed in 1968, 40 was old. You know, most people these days will say 40, but it's anything 40 and older. And some laws have a limitation of 70 in there. In fact, there's actually a Georgia age statute which nobody uses because the maximum penalty is $250.
Oh,
yes.
So, but it's from 40 to 70. But there's no age limit on the federal law. You can work until the cows come home.
Well, what about people who are disabled? Aren't there claims that may be asserted because someone has a disability?
Absolutely.
Go ahead.
What kind of disabilities come up?
Well, the Americans with Disabilities Act is where you would assert that claim, and it was recently amended. The amendments to it became effective in 2009. And since those amendments, basically, from an employer's perspective, we treat everything just about as a disability, and that's what the amendments were intended to do. They were intended to broaden what is considered a disability. And so now, if you assert a disability or if your employer regards you as having a disability, your employer has a duty to accommodate that disability unless it would provide to be an undue hardship on the employer. So that's where the focus of it is now. It's really shifted from what is a disability to can the employer accommodate you? Does the employer have a duty to accommodate? What triggers the duty to accommodate? So we would probably treat everything as a disability unless it was something minor like you stubbed your toe or you have a paper cut.
The technical definition is a physical or mental condition that substantially limits a major life activity.
Okay, and on that note, Ruth and Tamara, we're going to take a break, and when we come back, we'll pick up on how you define a disability.
Okay.
To our viewers, we hope you will continue to join us as we continue this interesting conversation on employment. Hello, and welcome to Legally Speaking. If you're just joining us, my name is Jacqueline Bunn, and today we're discussing employment issues with our guests, Ruth Woodling and Tamara Woodard. Before we took our break, you guys were talking a little bit about in the workplace when someone needs an accommodation, what an employer is required to do.
Since you were representing employers, I'll let you.
So it's actually a multi-part test, but when we left, Ruth was defining for us a disability, which is something that substantially limits a major life activity. But there's more. You also have to be what we call, even if you're disabled, that's not enough. You also have to be what we call a qualified individual with a disability. And what that means is you have to be able to perform the essential functions. These are all legal terms of art, but you have to be able to perform the essential functions of your job with or without reasonable accommodation. So for example, Jacqueline is our host today, and one of her essential functions would be speaking to guests, for example. So if you came down with a disability, for example, something that affected your voice, and you couldn't talk, and there's no accommodation we could give you to make you talk unless maybe buying you a voice box. So if the voice box is $400, your employer probably has an obligation to buy you that box to help you perform your job, to accommodate your disability. But if the voice box is $40,000, they don't have the accommodation. Very big difference. And that's obviously an extreme example. I used a price range that makes it very clear what you would and would be required to accommodate, but a lot of cases aren't that extreme. We have an employee, for example, who is a stutterer, and he hasn't been able to move up within the company because when he gets in front of managers or other employees to make presentations, his stuttering gets worse. So stuttering, we think, is probably a disability. I couldn't find any cases where anyone's opined on it, but it's probably a disability. Now, there is a device out there that would reduce his stuttering. The question is, legally, whether we have an obligation to buy it. Morally, maybe we want to buy it. Maybe it's the right thing to do for an employee, but employers don't think that way. They think, if I do this for this employee and I have 200,000 employees, the next time somebody is a stutterer, or hearing aids is a very similar example, the next time somebody needs a hearing aid, do I have to buy that? So, you know, we don't look at things in isolated cases. We also look at things for what their precedential value might be, what precedent it might set for the future.
And let me add that the larger and richer the corporation is, the more likely they will have to pay more for the accommodation, because the standard is it an undue hardship to the employer? And if you're IBM or a company of that size, then it's less likely to be an undue hardship to pay the larger amount of money.
Than if you're a mom and pop company
Right,
with 5
exactly.
employees.
Right. Right. And not only that, it's interesting that the employee doesn't get to choose the accommodation.
Right.
If the accommodation is reasonable, the employer gets to choose it.
And the other thing about that is it's the employee's duty to say to the employer, one, I need an accommodation, and you also have a duty as an employee to identify, at least try to identify an accommodation, because an employer has a duty to engage in what's called the interactive process. So once you as an employee say, hey, I have a disability and I need you to accommodate me in this manner, the employer has a duty, maybe not to choose the accommodation that the employee requested, but to try to find an accommodation that would enable the employee to perform his job, the essential functions of his job, his or her job, without it being an undue hardship. And there are a lot of things that the employer is not required to do. It's not required to give you the accommodation of your choice. It's not required to reallocate duties, so it's not required to make another employee do your job. It's not required to eliminate what we call essential functions of the job. So, for example, in our example earlier about talking or being able to speak to guests being an essential function, an employer is not required to eliminate that essential function and say, hey, well, why don't you have a Twitter interview, or why don't you do your interviews in that manner? So employers aren't required to do that. And there are a whole host of things that employers are not required to do, but it does have an affirmative duty to try to accommodate.
And that's another reason why a job description is really important, because that shows what the essential functions of the job are. And if you have a job description and the person can't perform some of those essential functions with accommodation, then, you know, there's no claim.
Okay. What if, let's take it a step further, what if you have an employee who has a relative that they're caring for who has a disability? Do you have to make accommodations for that?
that really comes under the Family and Medical Leave Act and not under the Americans with Disabilities Act. And the Family and Medical Leave Act applies only to employers with 50 or more employees within a 75-mile radius. And I think you have lots of experience with that.
We do. That's actually where most of our claims tend to come from because of our attendance policy. But you don't have a duty to accommodate the employee. You do, however, have a duty to give the employee time off from work to care for a loved one, care for his or herself, children, immediate family members, people who are returning from service, military service. And the requirements are a set number of 12 weeks of unpaid leave within a year period. You can force an employee to use his or her paid leave. So if you get 3 weeks of vacation and you need FEMLA leave, as an employer, I can force 3 weeks of that 12 weeks. I can force you to use all of your paid leave for that time. There are some requirements. You have to work a certain number of hours, 1,250 hours, and you have to have a year's worth of service before you're entitled to that. And what that does for you is it's a job protection leave. So if you take what's known as family medical leave, your employer has to return you to the job you were in or a job within a similar category, same rate of pay, same grade.
Okay. It really came about because people believed that if you were pregnant and you came back to work, you had to be rehired or placed in your same job. And the fact is that Title VII did not require that. Okay. And so that was really the impetus for the Family and Medical Leave Act, but it covers more than that. It covers more than, you can take also intermittent leave under the Family and Medical Leave Act.
You don't have to take it all at the same time.
No, you can take a half a day to go get treatment, for example, or to take your child to get treatment or something like that. But with pregnancy, you have to take it all together. You can't take intermittently.
Right.
Okay. What about someone who wants to take time off for religious observance?
You generally have to accommodate that if the employee has a firmly held moral, ethical, or religious belief. But I think we were talking earlier about a case that I had when I was on the defense side where the fella decided that he belonged to a lunar religion and that he and his family celebrated in the basement and that every 28 days on the full moon, that was their holiday, so he got that day off. And we decided that that was not a sincerely held, bona fide religious belief. But there was another one. It doesn't have to be an organized religion. Mm-hmm. It can be a moral or ethical belief.
Okay.
And one that I found interesting was a bus driver, a young woman who was a bus driver. And Burger King advertised on the side of the bus, and they also required her to hand out coupons. She was a vegan, and she believed that eating meat was morally and ethically wrong. And so she refused to hand out the coupons. And they fired her, and she prevailed. So that's just an example of something that's not an organized religion that was upheld.
What's sexual harassment?
Go ahead.
Should do the definition. Definition is?
It's unwelcome conduct. The unwelcome conduct that's pervasive and severe, and it's harassment based on sex, meaning that person is targeting you because you're a woman or a male. And a lot of people probably don't think of it this way, but there can be, not just male on female, female on male, but also male on male, female on female harassment. We're starting to see a lot of that, and harassment can come in many forms. It's not just touching. It can come through emails. It can be pictures of very, in this technological world we're in. It could be text messages. It could be stuff posted on Facebook or Twitter. If it's people that you work with and it's unwelcome, meaning you don't want them showing you these things. So it can be jokes, it can be pictures, it can be gestures, it can be touching, it can be words. It could be any number of things. You having inappropriate things at your cube or your desk and people coming by and complaining about it. But any type of unwelcome conduct that's directed at you based on your sex.
And it has to be unwelcome. Now, that doesn't mean that it has to be voluntary. There's a famous case on that, Meritor Savings Bank versus Vincent, that came out of Maryland, where there was a woman who worked in the bank, and she was promoted, and she got raises, and after a few years, she left and she sued, claiming that she had been subjected to a sexually hostile environment because her boss required her to have sexual relations with him. And there was no economic detriment to her ever. She was never, there was no...
Demoted?
Nothing. Okay, so, and she admitted she had sex with him at least 50 times. So the lower court said, this is clearly voluntary. And further, she had no economic detriment as a result of this. Well, it went to the Supreme Court, and they said that's not the test. The test is whether it's welcome. And she claimed that she did it. She, you know, he didn't hold a gun to her head, but she did it because she was a single mother and she needed the job. And so it was voluntary, but it wasn't welcome. So that's where you got to be careful. And if you're the person who's engaging in the harassment, who knows whether it's welcome? The person that you're aiming the conduct at, not you. You don't know whether it's welcome or not. That person knows whether it's welcome. So that's what's so dangerous about this.
And 2 points I think that Ruth, you raised. One is when you're talking about whether it's welcome or whether it's pervasive or severe, you can't take an unreasonable stance on that. So it's, even though it's based on what Ruth thinks, it's also the objective side of Ruth, right? So would an objective person in Ruth's position view that as unreasonable or unwelcome or severe and pervasive?
Tamara, I'm sorry to interrupt, but we have run out of time. I'm sure we're going to have to do a part 2 on this one. This has been so informative. To our viewers, thank you for joining us. I'd also like to thank the producer of this segment, attorney Julia Latimer. My name is Jacqueline Bunn. This has been Legally Speaking, brought to you by the Georgia Association of Black Women Attorneys.